Recently we had a public event where we invited folks to come and hear several speakers talk about things that had to do with funeral service and estate planning and memorialization. And at that event, which we held at our Boardman Chapel, we had the local probate judge, Judge Robert Rusu, come and speak about estate planning issues and problems that would occur if you didn't have a will, if you didn't have a power of attorney. And it was very well received. It was extremely informative. As always, Judge Rusu does a great job, and I would like to share it with everyone. So my thought is if you have the time, please listen, and I think you'll get quite a bit out of it, and I think you'll enjoy hearing the judge speak.
Thank you. I always like when people are eating when I'm talking, because I know they're at least doing something and getting something out of it, so you're getting your nutrition. So if you pay attention to my slideshow, I don't care, it's all right, just enjoy, keep eating. I am the probate judge of Mahoning County, and when we talk about making impressions, this is one area where you don't want to make an impression and make the wrong impression. You want to leave a good impression of yourself. And many times when I was in practice with Joe, children would come in and say, I want to do everything so I don't do what my parents did to me. I want to keep this easy for my children. I want to make my estate as easy as possible. I better stand close to this. I got to move around, sorry guys. I want to make my estate go as quick, as easily as possible that doesn't cost my family a lot of money, a lot of effort, or any controversy. So this is the area where you really need to pre-plan. You're going to hear that term pre-planning a lot tonight with funerals, with your final arrangements, and also with legal related matters. So I want you to take that away, is that the best thing that you can do for your whole family is do things ahead of time. Because if you wait too long, it's too late. And then somebody else may be making the decision for you, like me, the judge. I may have to make a decision for you that you wouldn't have made for yourself. But I have to make that decision based upon the information and the evidence that I have in front of me, which may not be what you like. So we're just going to talk a little bit about 4 key documents that I want to see everybody have, whether you're 18 years of age or 118 years of age. It doesn't matter. There's 4 main documents. One's called a last will and testament, and that's what we all saw on the old Perry Mason show when they read the will. You went to the lawyer's office and read the will. It's your last will and testament. That's a document that disposes of your assets, names an executor to handle your final affairs, and also could name a guardian of a minor or an incompetent adult child if you have children. That typically is the document that disposes of your assets that we all have come to know. But as you're going to learn here a little bit later, that's not necessarily the case. We still want you to always have a last will and testament. But if you do things and you do proper planning, you may not ever need to utilize your will, because you can do some things with planning techniques that can avoid the probate process and save you time and save you money. The other document, the second document, I'm going to run through these kind of quick because I don't have a limited time, so I'll answer these later if you have more specific questions. But the second document is called a durable financial power of attorney. That's a document where you nominate somebody to handle your business affairs for you, to be able to write your checks, to be able to handle your tax returns, your investments, to do your day-to-day business affairs. If you're incapacitated in a nursing home, in a hospital room, somebody can take care of those affairs for you. This avoids the need of a guardianship down at the probate court. You can imagine if you're paying your bills right now, if something happens to you and your spouse and you're sick or you can't handle it, who's going to do that for you? The bank doesn't know. They need a document that tells them who can handle that for you. And that's what this durable power of attorney does. You nominate your oldest son, your oldest daughter, maybe a brother or a sister, a close friend or a relative to handle those important business decisions for you. The third document is a living will. That is a health declaration. I like to call it a health declaration because people get confused with the living will and the last will and testament. They're 2 different documents. The living will is just your wishes regarding end-of-life decisions. What do you want done regarding medical end-of-life decisions for you? Do you want to be put on a respirator or a ventilator? Do you want watering tubes and feeding tubes given to you? Do you want to be an organ donor? Those are all things that you can put in your living will that is your wish that you're conveying to your family if you can't convey it in the future. And a lot of us, because of strokes or dementia, can't voice that later in life. This document you do now while you're competent that gives those directions to your family, so nobody's sitting up in an emergency room trying to decide what did mom and dad want us to do with them. It's very clearly spelled out. You go over that with your lawyer and doctor if you'd like, and it's a very simple document to do. The other document is a healthcare power of attorney. That is another medical form, but this is a decision that, or this is a document that handles day-to-day decisions that you make every day, such as, do I get a flu shot? Do I switch to a generic drug? Do I change insurances? Do I go to an HMO rather than staying with traditional Medicare? If you can't make those decisions, you need somebody to make it for you. What if you want to go in and have somebody go into the doctor's office with you and get your medical information? You can only do it if you give them the power to do that. They can only get that information if you authorize it. So this document, this healthcare power of attorney, I think is probably one of the most important documents that we can have as we start to age. Because we all know we have medical problems as we age. And so we may need somebody to make those decisions for us. End-of-life decisions are incorporated in this, but also simple day-to-day decision-making regarding medical affairs is incorporated in this. So those are the 4 documents I want to see everybody in this room have. If you have these good, or these 4 documents, you have a very solid financial future. And you're leaving a legacy for your family that they're not going to have problems with you later in life. When you draft these documents, these are some of the things that you want to keep in mind when you're talking about with your lawyer and your family when you're talking about drafting these documents. You want to avoid some of these pitfalls. And I've incorporated some famous people because everybody likes to talk about the rich and famous. So we're going to talk about how these guys screwed up so you don't get in that situation. When I was doing the research for this, 60% of Americans do not have a will. So that's 6 out of 10 of us don't have a will. That's scary. And that really surprised me. I'm telling you, I want you to avoid probate, okay? I get paid whether you come to probate or not. So if I can keep you out of probate, I can work less. So please, do these documents so you don't have to come to probate, and then I don't have to work as hard, okay? But let's talk about Jimi Hendrix. Jimi Hendrix, he did not have a will. He was called what we call intestate administration, dying without a will. So the state where he died has an intestate succession statute that says who gets your assets. It's the state telling you who is going to get your money. In Ohio, it's a pretty simple statute. It says it goes to your surviving spouse. If you don't have a surviving spouse, it goes to your children. If you don't have any children surviving, it goes to your grandchildren. If you don't have any grandchildren living, it goes back up your line of lineage to your mom and dad. If your mom and dad aren't surviving, then it goes to your grandparents. If your grandparents aren't surviving, then it comes back down the line of lineage and it goes over to your brothers and sisters. So that may be fine for the majority of people. And the legislature in the state of Ohio says that's good enough for most Ohioans. But maybe in your particular situation, maybe that's not right. Maybe you want your assets to go to a charity. Maybe you want it to go to an alma mater. Maybe you want it to go to a close friend who's taken care of you for a lot of years, and you feel close to them and you want to give it to them. Or you want to leave a legacy with the Youngstown Foundation or the Community Foundation. It doesn't go that way if you have it up here and you don't put it in writing. So you have to have a will. So Jimi Hendrix died at the age of 27 in 1970 without a will. For 20 years, a California attorney managed his estate while they were wrapping up all the affairs. 20 years takes a long time. It was a big estate. And Jimmy's father, Al, he said, hey, you know what? I want a piece of Jimmy's estate. I want to handle that estate. I'm going to take it. So he sued the estate, and he was awarded the estate and he amassed the estate to about $80 million. So he managed it while he was alive. But here's the kicker. When Jimmy, Dad, got the money, you could imagine, he was a rich man now, he got remarried. And he married a woman who had a child from a previous marriage. So Jimmy's father liked this girl, and he adopted her. So he brought this girl into his line of lineage in the eyes of the law. So when he died, when Jimmy's dad died, his estate went to his new adopted daughter. Jimmy had a half-brother when he died. They did not share a father, they shared a mother. Jimmy was very close with this half-brother. The half-brother ended up getting 0 assets from his own brother's estate, and it went to a girl that Jimmy did not even know when he was alive. So all this $80 million went to his would-be stepsister, but in the eyes of the law, because his dad adopted her, it's now his sister. It went to her, and nothing went to Jimmy, because Jimmy's dad was controlling his estate, and not Jimmy telling what he wants to do with it. Jimmy could have simply did a will that says, I leave all my assets, half to my brother, half to my dad, half to charity, or whatever he wanted to do, but he didn't do that. So other people get involved, courts get involved, litigation gets filed, and this is what happens with Jimmy's estate. Everybody knows Jurassic Park, the big movie with the dinosaurs. My kids love that. This is an interesting situation. The author of that, Michael Creighton, he had an outdated will. He had a will, but it was outdated. He didn't update it. You should always look to update your will. April 15th is the perfect day in everybody's life. What is April 15th? Tax day, right? Yeah. You're always dealing with your money, your finances, your 1099s. That's a good time to bring out all your stuff and take a look at it. Because you're just making sure everything's up to date, making sure you filed your taxes, you have all your 1099s there, you can list them all down so you know where everything's at. Just take a look at it, because Michael didn't do that. He had an estate worth $175 million. They make a lot of money off of dinosaurs. Keep that in mind. Barney, Jurassic Park, those dinosaurs go big time. $175 million estate. His will was not updated. And it said that he disinherited any future-born children, which is very unusual in a will. Most of the time you say, I want to make sure I take care of any children that are born after I would pass away. So if my wife and I had a children in what is it, in vitro, in vitro, yeah, whatever. You know what I'm talking about, sorry. The children would be included in the estate. Well, he had a provision in his will that was the exact opposite. He said that if there were any children born after I died, they did not get any of his estate. And lo and behold, his wife was pregnant, his current wife was pregnant when he died at a very young age. So what happened, there was a huge court battle because $175 million brings out a lot of lawyers. There's no shortage of lawyers when there's $175 million around. So this went through a big estate, or a big controversy, cost a lot of money, and he could have simply avoided it by just going in and updating his will and saying, hey, I need to take out this provision and include my new child that's going to be born. Even if you don't know their names, you can still include them in there. So that's just not updating the will. That's why I put that in there. Make sure you update your documents. Pull them out, take a look at them, make sure who's in there, who's not in there. Whitney Houston, everybody loves Whitney. Great voice. Her problem was that she didn't avoid probate. She didn't have her documents set up the right way. Whitney was worth a lot of money. You can imagine, she was an actress, she was a singer, she was a diva. She had a lot of property all over the United States, even outside the United States. She had property in California, Vegas, New York City, and I think there was a place up in Cape Cod, Maine, and then she had a couple places overseas. Paris, France, I think, somewhere over there. She didn't set up a revocable living trust. If she would have set up a revocable living trust, which is a way to own your assets and control your assets after your death, like a last will and testament does, but it also allows you to own assets in different states. So when you die, the asset can still be transferred or sold without the need of a probate administration. It saves your family a lot of time and a lot of money. Trusts are not for everybody. If you look at the TV and you look at some of the things coming in the mail probably, everybody says, oh, you need a trust, you need a trust. Not necessarily. Go in, sit with your lawyer, talk to them, see what's good for you. In this situation, Whitney didn't do that. If she would have sat down with an attorney, estate planning attorney, by the way, he would have told her, hey, listen, you have property all over the United States. If you die, we have to open up a probate administration in each one of those states where you have your assets. That costs time and that costs money. So that's what happened to Whitney. She ended up costing her family money unintentionally, because she could have avoided that by having one trust, one trustee, have all the assets titled in that trust, and then the trustee could have disposed of it when she died. Nobody would have been none the wiser. It would have been private document between the beneficiaries, and it would have saved a bunch of money. So make sure you talk about to your attorney about what's applicable to your situation, not your neighbor, not your friend, not your brother or sister. What's applicable to your situation? I have 4 children. I know Dave, he has 2 children. I have some friends that don't have any children. So the things that we would plan would be different for the 3 of us. That'd be the same thing with you. You can get information from your family and friends, but make sure you go get an expert to talk about your particular situation. This is a good one because I like this. This is a judge. This is former Chief Justice Warren Burger. This guy was just a cheapo. He didn't want to pay a lawyer. Former Chief Justice of the Supreme Court. He's making some pretty big change, okay? He's not hurting for money. But he decided, oh, you know what? This is easy. I'm going to do my own will. I'm going to draft it myself. This was before LegalZoom. So he went on and he did it. And what he did is he forgot to put a clause in the document waiving bond. And he also forgot to include what they call a powers clause that give the power of the executor to do things on your estate's behalf, such as sell real estate, to liquidate stock. He didn't put those powers in there. These are very basic powers that any good estate planning attorney knows to put in your will. Well, he forgot to do it. His estate was about $1.1 million, not a huge estate, but still $1 million. His family ended up paying an additional $450,000 in tax return, or estate tax, and bond premiums that could have been avoided if he would have simply paid about $1,000 and got an attorney to do it the right way for him. I say $1,000 because it's a big estate planning package that he could have done. For most folks in Mahoning County, Trumbull County, the average estate plan with all those 4 documents that I told you about are about $600 to $700. So it's a very inexpensive procedure. His was a little bit more because he was in Washington, D.C., and you pay the bigger prices up there. But I like this to tell people, make sure you get somebody to do it right. I tell people I could change the oil in my car. It's pretty simple to do, but it's easier to take it to Jiffy Lube because they know what to do with it. You pull in, you don't even have to get dirty. They change it, pay the few extra bucks, let the professionals do it for you. How much time I got left? Want me to shut up now? Okay, I'll go a couple more. This is here's a common pitfall, not telling your family where your will's located at. Make sure you put down where your stuff is located at. In today's society, especially because we're getting paperless, everybody's getting their online statements. You don't get your bank statements anymore. You don't get your canceled checks. Make sure you write down where your assets are located at, what the passwords are for your accounts, and also where your important documents are. Let them know if you keep them in a safety deposit box, if you keep them in a safe at home. If you keep them in the safe at home, make sure somebody has the key or the combination of the safe. These are just common things that we forget to do, and that's what happened with Florence Griffith Joyner, who was the famous FloJo. She was a track star. She forgot to tell her husband where she left her will, and they could never find it. And there was a big controversy because she promised her mother that she could live with them in her house in California with her husband after she died. She gave her mother a life estate in her house, supposedly. It was supposedly in the will, but nobody could find the will. So when Florence died, Florence's husband told his mother-in-law, "Get the hell out. I don't want you living here anymore with me." He could have been the one who maybe destroyed the will, but you want to make sure people know where it's at. And that was a big an ordeal that went in court. This is another kind of a similar one, like the Jimi Hendrix estate, Marilyn Monroe. Everybody knows Marilyn Monroe. A very similar situation. She left everything to her acting coach. He was very important to Marilyn Monroe. She left the bulk of her estate to him. When he died, he left his interest in the Marilyn Monroe estate to his wife, Anna Strasberg. She then sold that to this Authentic Brands group for $50 million. Her estate is still making money, grossing about $10 to $15 million a year in royalties. So every time you see her face on TV, she's making money. Same thing with Elvis Presley's estate, Buddy Holly. All these famous artists are still making money. Their estate's bringing in money. So Anna Strasberg sold the Marilyn Monroe interest to this Authentic Brands group for $50 million. And now she has that money and she's enjoying it, and she never even met Marilyn Monroe. She didn't know who she was. She wasn't important to her. So Marilyn could have simply provided that she gave everything to her. She could have played the what if game and gave everything in a trust for her acting coach for a certain period of time, for his lifetime, and then whatever was left, she could have left to her family, to charities, or to do something for other people, and not go to some of these other people that she didn't even know. Okay, so I gave you examples of bad things. I'm going to give you a couple examples of good things. And here's the good thing, are the Kennedys. The Kennedys are good because they always have good lawyers. Our president, JFK, when he died, he had an approximate estate worth of $100 million. Everything that he had a pretty sophisticated will, but most of his assets were in a revocable living trust that I was telling you about, and everything was very private. So if you try to find documents on what happened to JFK's estate, you're not going to find it, because the only people that find out about it are the beneficiaries of his trust. It was a private document. It kept in the family. Nobody knows anything that happened. So he did it right. Nothing went through probate except for some minor personal property items. And it could be still being managed today, for all we know, but because it's a private document just between the beneficiaries, nobody knows about it. So he did it right. And then, unfortunately, his son died at a very young age. You remember he was in a plane accident going over to Cape Cod, I think it was, or Martha's Vineyard. He ended up dying at the age of 38 with his new wife, Carolyn. They did have a will, and they had a provision in here that said if they died simultaneously, which they did, they died in a plane accident together, that they wanted their assets to go to his sister's children, which would have been Carolyn's children. So their will ended up passing the assets the way they wanted it to go to. If not, the state of New York would have told them who would have gotten this money. And it didn't, they didn't want it to go that way. They wanted it to go to their nieces and nephews. So this is an example of doing it the right way. There's a lot of people that do it the right way. But the only way you can do it the right way is to get in, sit down, talk about it. Nobody likes to talk about death, but it's part of life. So if you face it face first, it's not scary. You can control the outcome, and you can have some peace of mind knowing that you set up your family and your wishes are going to be followed. So I thank you. I hope you enjoyed the presentation. The dinner smells good, so I'm going to go eat now. So.